Okay, for the appellants in Metuh, Chief Metuh, against the Federal Republic of Nigeria, we are happy, but not fully happy, because what we expected from the court was a total dismissal of the judgment of the lower court, not an annulment. If you remember, from the 15th day of February, when the charges were preferred against Chief Metuh and his company, myself and Dr. Onyechip as SAN and other counsel for Chief Metuh complained of bias and lack of fair hearing. We did complain, we were lampooned, the court was so hostile to us, and on a given day, if you look at the judgment that has just been annulled, if you go to page 152, you will see where a judge, Justice Sabang Okon-Abang, wrote in black and white that because Onyechip SAN made a case of bias against him, that he would have disfigured his chemistry. I quoted his language, disfigured his chemistry, but that he has decided to leave him. In the bid to discredit the lawyers to Chief Metuh, Justice Okon-Abang went ahead to label me a serial petitioner. Today, the court has gone through the record before Justice Okon-Abang, and they found out that nothing he held on to was in that record. And so it took us coming to Court of Appeal for the court to hold that there was bias and lack of fair hearing. We are very happy that we got to this point, because when we were saying it at the lower court, we didn't have a microphone to talk to the public. It was only the judge, Justice Okon-Abang, that was speaking, and the whole world was hearing him. At one time, even in his judgment, he alleged that we went to CNN to make a case for our client, just to paint him in bad light. Unfortunately, there was never anything like that. CNN never knew about this case. And so today, the Court of Appeal has held that that judgment, that exercise that lasted from the 15th day of February 2016, 15th January 2016, till 25th day of February this year, that all are a nullity. And why are they a nullity? Because the jurists showed elements of bias. You see, to prove bias in a case is very difficult. But the judge made it easy for us because he put it down in writing. And today I leave this court knowing that I'm not mad, knowing that I have done no wrong, that I just walked into a case where a determination had been made to send Chief Metuh and his company to jail. And I'm happy about it. On the issue of retrial, we'll look at it, we'll consult with our clients, and then we'll know what to do. But we're at least happy that the issue of bias was established, lack of fair hearing was established, and nothing can change it. No, it has been annulled. The trial has been, what took him to jail has been annulled. And so it is just a matter of protocol for him to leave the prison. He is not a convicted man. That is administrative. We are going to conduct an administrative action. But as of today, Chief Metuh is not a convict, as he has been labeled. And it may interest you to know that Chief Metuh has been in prison for virtually 10 months. 10 months because of a judgment that has been adjudged to be a product of bias and lack of fair hearing. But we all, that's God, like we know in Nigeria. God will always do his own. Man can do his own, but God will do his own. And so we thank the Court of Appeal that they have been bold enough to find in our favor that we did no wrong. Thank you.
Thank you.
Thank you.